time where the council officers will get a verbal response to the evidence received. I think we've got a procedural matter that I think we need to deal with quickly. I've been forwarded an email from Ms. Tai here from Ms. King regarding her submission that she wants to table some evidence to support her submission. So I understand she's not attending. Now, just to clarify, Ms. King is relative of yours.
Yes, I'm not going to partake in the deliberations on this matter.
Yeah, but she's your.
Yes.
Yeah. So I think the way we deal with that is, I mean, it's tabled. It's for council officers to have a look at and comment on. Should you wish to, and you write a reply, you don't have to do that immediately. And I think what we do is we'll just, when it comes to that part of the deliberation, we just stand aside and not take part in that part of the deliberation. I think that should clarify any conflict of interest.
Thank you, Mr. Chair.
Okay, over to you.
Thank you, Mr. Chair. Perhaps go through some of the initial questions. Just again, as we run these things, we essentially enter into an arrangement with the panel over the things that they do want to hear from specifically, and we tidy that up with any additional matters that the panel wish to ask of us specifically as well. I've noted a number of matters as part of the introductory today. So I think there was a few topographical issues with some of the paras and hazardous substances chapters. Will resolve those in submitted numbers. There was questions around mapping and particularly the coastal geomorphology, where the underlying geomorphology has been taken into account. We've answered that, but I think it might be more benefit from maybe some more explicit confirmation from the source if we can, just to confirm that. I think we have answered the question around updating the layers, particularly for the river flooding protection, particularly subsequent to river flooding protection where it's being completed. I think we've answered that, but we can also, again, give you a quick paragraph to summarise that as well. Acknowledge that there were some questions around how the coastal chapter will look. I think Mr. Wyeth might be able to provide some thoughts on that as well, bringing together natural hazard aspects with the remaining coastal aspects, again highlighting some of the complexities with the National Planning Standards approach to certain matters. So Mr. Wyeth will provide comment on the rules, amendments, the provisions that the telcos have provided, after hearing from them and understanding the direction of some of the reforms that are coming in play around the ES and also potential infrastructure in PS. There was quite a lot of discussion around policy 10 and the lack thereof of an associated objective and supporting infrastructure, particularly upgrade and maintenance of existing infrastructure in natural hazard areas. Again, Mr. Wyeth will respond to that in his right of reply. There was also some detail around some of the language in the standards. I think we might benefit from the natural hazard chapter, just provide us some clarification over when and what and how they apply. I think Mr. Wyeth appropriately explained it, but it might be useful to have that in writing, sir. Federated farmers, again, obviously we've given us a bit of a steer around the Building Act and the buildings that are permitted there, particularly the 110 square metre provision that's likely, we'll take that into account. And also the comments from Federated Farmers regarding the hazardous substances chapter and whether it's intended to capture things like milk storage on site. The report writer will actually respond to that for your well-being. We're not entirely sure whether there are any outstanding questions arising from the presentation of carbon neutral, other than to perhaps set a scene for future hearings down the line. So we haven't got any obvious questions or point of clarifications that you might wish to from our thinking for you at this stage, unless you've got anything you want us to answer in response to that evidence.
Yeah, I think they were just making a general comment about the need to manage flooding hazards and that they signalled that they're particularly concerned about that particular area. We'll hear more from them.
Thank you, Mr. Chair. Are there any outstanding questions from the panel that you'd like clarification from us?
Yeah, I think there probably is a few. I'll start with Commissioner Kensington.
Yeah, thank you. There's two things in there from the table evidence.
Yes.
We probably should have asked Mr. Batten when he was here. He was representing foodstuffs. He's tabled a letter. And where he doesn't support the recommendations for rule NHR2, I wonder whether that should be NH rule R3, talking about the GFA restriction at 10 square metres. He thinks that's too restrictive. I wonder whether we clarify whether it is R2 or R3. But yeah, whether you've got a response to that specific suggestion. And then the second one was Mr. McPhee, Fletcher Building in Waipapa Pine. He's recommended a couple of changes to one to the hazardous substances chapter, rule R2. And he suggested some wording changes there, and then also to natural hazards R2 and R3 as well. So having a response from this time on those would be helpful.
My apologies, Mr. Chair. Actually, Mr. Wyeth had actually pointed out that those were matters that he was going to respond to before, so I apologise for that oversight discussion before. But yes, those right on radar. So
Thank you. That was all. I mean, is there anything we need to hear about those things now, or should we just wait for the reply?
Jerome, is there anything you'd like to?
I'll leave it open to you, Mr. Wyeth. I mean, you can give us a response now and your written response.
Written response, but I think the clarification around R2 and R3 is R2 refers to the thresholds and R3s. That's kind of overlapping, so I can clarify that. But I think that the key concern there is around the 10 metre increasing the threshold and that being too restrictive. Yeah, so I will certainly look at those, and particularly as it relates to the heavy industrial zone, which is Andrew's focus on.
Yeah, and the flooding and in various areas. Yeah. Thanks.
I just had a question about the wildfire change that was limited to urban zones, and I just wanted to see clarity around that you did speak about that in the US about that change because it was in your view too restrictive, so you changed that to only be in an urban zone with a setback at least 20 metres to allow for vegetation on someone else's property. And so in terms of any rural zone, just off the top of my head, and the setback of any building, 10 metres is a permitted activity. This is a setback of it from a boundary.
I need to look back at the rural zone rules, but I believe they are along those lines.
So with this change only applying to urban zones, then I guess my question is why 20 metres and why just the urban zones?
So the 20-metre setback that comes from the district.
Correct.
And the concern I had, well, I heard from in submissions was that that can trigger unnecessary consent requirements, particularly in urban environments when you've got less ability to move away from the neighbouring properties and they have scrub right on that boundary. Whereas in a rural environment, in general terms, you probably have more ability to be set back from neighbouring vegetation or vegetation more generally. So that was the basis for that recommendation. I can certainly consider that further if you'd like. But sort of the strong feedback from PINs is that that setback is important to retain for control purposes. So I was just trying to make it a bit more as it applies in urban industrial environment. Sense. I can look at that further. There is an issue with the definition of urban that we came up in hearing 4. I sort of put it there as a bit of a placeholder saying generally we're trying to capture these urban zones. We will not be aimed at definition of urban zone, or whether the standard becomes more specific to the zones that are captured or included in the state. I can consider further, but it was more sort of putting it out there, and that's the concept. That's the idea, is to not apply it in urban environments.
Because the other question I have was around the definition of a contiguous scrub or scrubland, wood or forestry. Definition, I see that the words have been outlined there, but when it comes to the definition, hearing, I think I'm on as well. I wasn't sure if it could be addressed as well in the definition to allow it to be more workable in a rural, in particular lifestyle zoning as well. So either within the rural or within a different definition.
So my understanding is those words are again directly from the
Current
district plan. Yeah, contiguous scrub and shrubland with and or forestry is not defined.
Correct.
Are you asking whether there would be value in defining those?
Yes.
We can consider that. Defining contiguous scrub may be problematic. But we can consider. I have had conversations with the consenting team at FNDC about these rules and trying to make them sort of workable. That, we didn't have any magic solutions, I guess, is the answer, but they did consider, they are aware of these rules, they implement them in practice. They are at the moment triggering serious consent requirements, I understand, particularly in urban contexts. That was the basis of my recommendation, but I can certainly look at that rule a bit further and see if there's any further opportunities to refine it and make it more workable.
Just to highlight that, I'm bringing this up now because we've already had our hearing relating to vegetation clearance. So the two interrelate. So we might want to clear some Indigenous bush to allow for mitigation of fire hazard, but then it also might trigger another rule under another chapter of the plan. So just highlighting that in terms of opposing sections of the plan and getting that balance.
By memory, there's one of those permitted activity pathways is to maintain that fire rate, that 20 metre setback. And I have heard concerns that it's been abused in some ways, and that you put your dwelling in there and then you can kind of clear around it to sort of maintain that setback, where ideally you can away from those areas of bush where you can. But I can look at that relationship as part of our reply, but the intent is that they can talk to each other in that respect.
Yes.
So that means having another look at the IB part of hearing 4.
I do remember a lengthy discussion
That
about
needs to be done. Like I said, we saw hearing 4 as the real engine room of the plan. That really is where a lot of stuff happens. And so we're expecting it, you have to go back to those provisions again as we work our way through. So that'd be helpful, I think. So I suppose what you're trying to say, like if you summarize it, you're probably misrepresented it, is that you want to make sure that the permitted activity status to allow clearance of vegetation, of the separation distance, doesn't butt into the provisions that limit clearance of vegetation.
Correct. Yeah.
in some, and I think Mr. White, what you're saying is in some cases, you may want that vegetation, that the rule not allowing that vegetation to be cleared in order to encourage a building to be further away.
Yeah, I guess it's the difference between creating that 20-metre buffer versus maintaining that buffer if it's kind of encroaching onto an existing residential.
Yes,
So
yeah,
you
it's going to be a delicate
Yeah.
balancing thing. And it won't work in all circumstances, but that's often the problem we have with planning provisions is just make them try and butt up against each other as least as possible.
And just another point about that, the current operative plan refers only to residential units, whereas this new rule here, permitted rule refers to extensions and alterations, but then also refers to, it excludes accessory buildings. So just the difference between those issues under the current operative plan and how we can address it under the.
And that the rules in the PDP relate to vulnerable activities, which encapsulates residential activities and a number of other sensitive activities. I can bring that up, but so it is sort of carrying through there. Like the focus is really residential units, but there's other vulnerable activities as part of the that are captured by the rule. And that's more the general approach of the natural hazards chapter, is it identifies specific vulnerable activities where a different sort of policy and rule-based approach is taken in certain circumstances. But I can certainly look at that, and we could just be focused on residential units.
Thank you.
I've got a couple of questions that sort of relate more to the hazardous substances chapter. And they're sort of reasonably sort of broad, and I'll confess, I'm not sure there are other submissions there that allow me to directly go there yet. But let's have the discussion anyway. Scope to go there or not. And these aren't really big issues. I just want to understand. So if you want to go to your chapter, the hazardous substance chapter, HS1 and HS2, and really want a little bit more clarification where HS1 sort of uses the word minimise, right? Hazardous substance people in the property are minimised to acceptable levels. It's a focus on minimisation. And then objective 2 then talks about managed. And I'm just interested as to why those terms were used for each of those objectives.
We can have a look at that.
Yeah. I'm sort of thinking, when you think about minimised, it's about effects. Minimise effects, but you manage risk. I mean, that might be a little bit simplistic from my part, but yeah, it's again, I'm not sure there's submissions that allow us to go there, but it jumped out at me as to why those words were used. It was probably genuine specific thinking at the drafting stage.
I mean, yeah, obviously minimise is about as much as possible reduce adverse effects where managers the activity that you undertake to do so. I don't have the specific references in front of me at the moment, but they might be doing two separate things.
Yeah, and if that's the case, that's fine. An explanation just understand that. Yeah, and then HSP2. Yeah, I see this phrase used often, and I'm always asked questions about it. It says avoid where practicable. And where does that really leave avoid? I think, what does avoid where practicable mean in practice?
Minimise, yeah.
Well, glad it came from you. I was going to say, it's sort of like the get out of jail free card of avoid means avoid. When does avoid not mean avoid? When it means where practicable. But I accept that may be deliberate. I just want a bit of an explanation of avoid where practicable. What does that mean in practice when someone's trying to And when someone says, oh, hang on, you avoid that, but only where practicable, where does that leave them? And I think, you hit the nail on the head when it said just minimise.
We'll look at it, Mr. Chair.
Sure. And it goes on to say, no, there's another one. P3. Oh, yes, manage new or expanded significant hazardous facilities and sensitive activities to address the effects. Does to address effects mean? Is it like would remedy mitigate?
What's the reference there, Mr. Chair?
P3.
Yeah.
Yeah, address the effects. I'm thinking would remedy mitigate.
So, yeah, I mean, this may be, I would hesitate to say that will be a chapter where is different in its technical nature, and I would say probably very lightweight in terms of its overall framework. Again, we'll refer specifically to what it says, but I would think when we have our right of apply, but on the face of what you've read, it seems to me like it identifies the things that we're looking to minimise the effects on in particular. So it might be a case of identifying those particular activities.
I mean, it starts with manage.
Yes.
So I sort of feel that it might be fitting in that manage. When you say address, you're talking managing the effects.
I mean, just to add those sort of, generally the last policy in a lot of zone chapters or a lot of chapters generally have that sort of consider type policy, and through earlier areas we sort of adopt some more consistent and direct wording, which is along the line of considering and following methods. You might have more here, it's a really considerations policy.
Yeah.
I'm not sure if that applies here to the neck. I'm not trying to speak for you, but certainly we're trying to move towards more consistent wording around those consideration policies.
So look, if you want to make a few tweaks, I'm sure we can find a submission.
Yeah.
Mr. Riddell's bound to have me that we can rely on.
We have to make a consequence.
There are submissions in relation to Ps 1 to 3.
Yeah.
So there is scope. So I will have a look at and take on board.
I mean, this is in the interest of, more directive and consistent. As you say, you may have already adopted another phraseology when you've looked at other policies that might.
Yeah, certainly, if it's a consideration policy, we have made consequential amendments throughout the plan to address that.
Okay, cool. Now let's move on to. Oh yeah, R1. Per 2, hazardous activity 2. Location of hazardous substances on the site will not be located closer to any sensitive activities. Does that mean it does not? It can move, but no, not close. I'm just wondering what closer means. And how does that create a little bit of an enforcement issue? And how you define what closer means?
Look, I think you would, the language might need a bit of tidy up, but again, I don't have the rule in front of me, but it seems to me that when you are looking at an application for a building consent, you would identify where the sensitive activities are and note whether.
So you're looking as a crow flies line, you'd think that's how you would implement that rule?
On the face of it, without going too deep into it, that would be.
I'm just be satisfied that that's a suitable level of certainty. But that's just the question. I'll leave it at that point.
Maybe when I look at all the wording to look at that one also and talk to 17.
Yeah. Now, just moving on to the natural hazards. That reference to the hyperlink. Removing the hyperlink. I think that was in the explanation of it. Oh yeah, paragraph 71. of the, auditor report. Just wanted to understand what that actually meant. And yeah, and flood hazard area is a hyperlink definition, but not the problem. Is what you're saying is, I'm just going to take the actual hyperlink out of it because we're not intending to define it? Or is it? Yeah. I think that's what it meant. I just wanted that to be clarified. Is it? Yeah, so that's why, yeah, explain question mark, just the hyperlink removed, question mark. In other words, the hyperlink begs the question that there's a definition, but there isn't one and you're not intending to provide one.
Yeah, I think that's the case, I'm sure.
Yeah.
Any change in the intent. It's just deleting the hyperlink, so.
Yeah, okay, no, that's fine. Look, that's all the questions that I have. A couple of others, but the other commissioners covered those, so.
Mr. Chair.
Anything else arising?
Just on that hyperlink, what did it hyperlink to?
Something that was going to be defined.
So at the end it defines, and the hyperlinks to a definition which talks about the 1 in 10 year flood hazard areas and 1 in 100 year flood hazard areas.
That's right.
But you've also got river flood hazard area defined, which says the same thing. So you go to like the overview section, there's flood hazard areas which defines, it goes to 110 year flood hazard area, 100 year flood hazard area, and then you have a definition of river flood hazard area which says exactly the same thing. So I was just looking at the overview and I was like, there's lots of words that say the same thing, can we simplify it?
Yeah, I get that.
And then the rules of the recommended amendments for that just refer to river flood hazard area. That's all defined, so it's quite specific. So another definition of flood hazard area would just add unnecessary confusion in my view. It serves no useful purpose.
Great, okay, well, then we can, any further comments? No, you're good. Okay, well, that brings, I just wanted to say again, it really is a testament to your good drafting and diligence to addressing, genuinely addressing the submissions and that I think a 3-day hearing has become literally a half-day hearing. And you've got that feedback as well from farmers. It's not just coming from us. So that's probably the best feedback you could get, really, as it would be. So well done, and we'll bring things to a close after the Kaikohe, and I look forward to seeing some of you in hearing 14, which is residential, business and industrial.
Urban, yeah.
Urbans.
End of July. Po hiri, po ramarama, po o te whakaaro, po o te tangata, po o te aroha. Ti po e hiri nei I a tātou, mauri ora ki a tātou, homie, huie, tahi. Thank you. I will stop the recording